Good morning, everyone, and welcome to our courtroom away from home. Oh, this is home for me. This is my law school, so we're very pleased to be here at Marquette Law School for today's argument. I would like to call the first case this morning, which is the Public Interest Legal Foundation versus Wolf. Mr. Johnson.
Thank you. Good morning. My name is Noel Johnson. I am counsel for the Appellant Public Interest Legal Foundation. I'd just like to quickly say, as a 2010 graduate of Marquette Law School, it's an honor to have the court here today, and I appreciate the opportunity to appear. May it please the court, voting rights should not be granted or removed in secret. Yet in Wisconsin, those decisions can be made in the dark because Wisconsin is exempt from an important federal transparency law, Section 8I of the National Voter Registration Act. To be sure, Congress gave Wisconsin that exemption, but the statute's text does not decide this appeal. Rather, the principle of equal state sovereignty, as articulated in Shelby County versus Holder, is what decides this appeal. Under that principle, Wisconsin's preferential treatment must be justified under current conditions. Yet the district court held that Wisconsin's transparency exemption requires no justification. This appeal thus presents a simple question. When Congress treats the states differently using its election clause powers, must that decision be justified at all? The United States has told us that some justification is needed, and we agree. Voting rights need protection in Wisconsin as much as any other state, yet Wisconsin remains exempt. When Shelby County spoke of the equality of the states, it was drawing from a fundamental principle and what it called a historic tradition that predates the Constitution itself. The states that founded this nation were both equal and sovereign.
Before you get too deep into the substance of your argument, perhaps you could address the threshold question about whether the equal sovereignty principle applies to elections clause legislation as opposed to legislation promulgated under the 14th Amendment, Section 5, which is the Shelby County situation.
Right. The district court saw a distinction between Congress's respective power sources. The Voting Rights Act was enacted under the 15th Amendment, whereas the NVRA was enacted under Congress's election clause powers. To be sure, the states surrendered some sovereignty when they passed the elections clause. It gives Congress the power to override state legislative choices in some cases. But the question here is whether the states surrendered their equal sovereignty, such as Congress could override those choices and burden some states and not others without justification. Now, to your question, the historical record, a look at the historical record would show that the principle articulated in Shelby County would apply equally to election clause legislation. For starters, this nation was founded on a principle of dual sovereignty. The states were given the right to run their own elections, and that Congress would override those decisions only in the last resort. And the proponents and the opponents of the elections clause were both concerned with giving unchecked power to states and Congress. And unchecked power is another way of saying unjustified power. And the proponents of the elections clause, who ultimately got their way, intended for the elections clause to establish uniformity and to give the people equal rights to election. So yet the district court's ruling means Congress does not need to act in an equal way with respect to voters and states. So the historical record, to answer your question, the historical record and the principles surrounding the founding of the nation, the powers that the states gave themselves.
But does anything in the Constitution support your view, historical record? There are actually 4 clauses in the Constitution that require states to be treated equal. The Tariff Clause, the Bankruptcy Clause, the Immigration Clause, and the Port Preference Clause. And the Elections Clause is not one of them. When you have some clauses expressly requiring uniformity and others that don't, what's the right inference to draw?
Well, I would first look at the Shelby County decision. The 15th Amendment did not require the states to be treated equally as well. And yet the Supreme Court drew on this fundamental principle predating the founding of our nation to say that Congress's 15th Amendment powers were qualified.
When you talk about a fundamental principle that predates our nation, are you saying that Congress has to treat all the states equally under all of its powers, notwithstanding the fact that the Constitution requires equal treatment only for 4 powers?
We're certainly not.
Especially if it says uniform with respect to bankruptcy, that implies that non-uniform is possible with respect to, say, the Commerce Clause.
We are not saying that Congress must treat the states equally in all instances, even under the Elections Clause. What we are saying is that when they do that, when they deprive some states of sovereignty and not others, that decision needs justification. That's the unmistakable lesson of Shelby County, that the principle enunciated there, articulated there, was a broad constitutional architecture that should apply in cases where some states are burdened, they are deprived of sovereignty, and others are not. So we're not asking for a sweeping decision saying Congress cannot act in this way. What we are saying is, in this instance, their decision to treat Wisconsin differently needs some justification.
Mr. Johnson, question about standing. Did the district court apply the incorrect test for informational injury by not considering whether TransUnion changed the law?
If you look at the TransUnion decision, Justice Kavanaugh was clear to distinguish public records cases and said that they did not control that inquiry because the petitioners in TransUnion were not denied public information. They simply received it in the wrong format. And so the district court correctly applied the cases that apply when a party requests public records and is denied. So those cases would be Akins and Public Citizen. That standing inquiry controls in cases like this, where public records are available and are not provided.
Can your client demonstrate downstream consequences like TransUnion requires?
We absolutely can, and we did include them in our complaint. My client wants to use this information for precisely the purposes that Congress envisioned, which is to evaluate the activities of government, to see if they are protecting the right to vote, to see if they are keeping voter rolls accurate and current. And so those downstream consequences, in the event they are needed, are pleaded in our complaint.
But this isn't really about access to information. The information is readily available. It's just how much you have to pay for it.
Well, I would disagree that it's readily available. When something costs $12,500 each time you want to see it, I don't think that that's transparency.
Well, if you want a reproduction of it, is what I'm talking about. Anybody can go into the office and look at it, right?
Well, I'm not sure anybody can just walk in and inspect it. Reproduction cost would, of course, require payment.
Right. But that's what we're talking about. We're talking about how much someone has to pay for a copy of the voter registration rolls.
Yes, that is part of the NVRA violation we allege. But again, the cost is relevant here, the reproduction cost, because as a matter of preemption, any state law that poses a barrier to what Congress intended would be preempted. And our argument is that a cost as high as $12,500 poses an obstacle to effective analysis of the voter roll to see if officials are doing or not doing their job. And Wisconsin actually sort of boasts on their website that effective analysis cannot be done because the public does not have access to date of birth information. So it is conceded that the law is designed to prevent the public from using it in the way that Congress intended.
The information that your client is seeking included the birth dates, correct?
Not the full date of birth, but just the year of birth.
Would your request, what would your request be in relation to Social Security numbers? Isn't there a privacy interest in that?
We have not requested Social Security numbers, and we do not want them. I'd like to just focus on another aspect of the district court's decision, which the court used to distinguish the Shelby County standard. The court found that the plaintiffs in the Shelby County case were complaining about the burdens of the law, and the plaintiff in this case is complaining about an exemption. And that was one of the chief reasons the court gave for why the Shelby County standard should not apply. Now, we think that's really just a distinction without a difference, and really a matter of perspective. In both cases with the Voting Rights Act and with the NVRA, you have a set of states that is burdened with a loss of sovereignty, and you have a set of states that is not, that is free to pass their own laws. So I think that distinction that the court drew simply does not adequately distinguish Shelby County and gives the court a reason to not apply the standard there.
But the remedy you're seeking is the invalidation of the exemption.
That's correct.
That benefits Wisconsin because of its very liberal voter registration laws, same-day registration, election day registration, which was the compromise that Congress struck in the Voter Registration Act. And so this is a unique application, at least we have to agree, of the equal sovereignty principle, because you're seeking to impose a burden on Wisconsin that it's otherwise exempt from under federal law.
I would agree that this is a unique application. I would say there is precedent, namely the Barr case, BARR, which we cite in our briefing. That case dealt with the Communications Act, and part of it that treated some speech and speakers unequally. And there was an exemption in that act for certain speech. And it was challenged, and the court explained a preference for severing that exemption over striking down the entire law. And the court actually took away preferential treatment from certain speakers in order to make all speakers equal. And so that is and the courts more broadly was saying when the problem is unequal treatment, then the remedy is equal treatment. And so the concept of Barr could easily be applied here because we're asking for an exemption or part of one to be severed in order to make the parties equal, but not just equal, to further the purposes of the NVRA. The result here would be that Wisconsin is subject to the transparency obligations of the NVRA, and their decisions about voter registration would therefore be transparent. And so in effect, we are asking the court to do the least it could do to remedy the problem.
But you're effectively asking us for a remedy that would vindicate the equal sovereignty principles of other states who do not have the exemption because their voter registration laws were stricter at the time that this legislation was adopted. And so they did not qualify for the exemption. So vindicating those states' equal sovereignty principles, your own interests as well, in terms of how much you have to pay for the voter registration information. So Article 3 standing, I think, is probably secure here because of the financial injury that your client has suffered. But it still is sort of an upside down application of equal sovereignty at best. I have not been able to find any precedent for this.
And I will just add that the bond and this court's decision in Gillespie addresses sort of that prudential standing question, whether we are asserting our own rights or the rights of states. And the district court got that right by saying the 10th Amendment arguably protects state sovereignty, but it does so to protect individual rights. So as much as the NVRA does burden other states, and it has a burden on my client as well because we can't get this information, the injury here we're asserting is our own. And I see I have just a little bit of time I'd like to save for rebuttal. Thank you.
That's fine. Thank you. Mr. Keenan.
May it please the court, Assistant Attorney General Brian Keenan on behalf of Megan Wolf, Wisconsin's Administrator of Wisconsin's Elections Commission. The foundation is asking this court to expand the holding in Shelby County well beyond its reasoning in a way recognized by no court in this country. There's several differences with what happened in Shelby County. First is that Shelby County involved Congress singling out a few states and counties for a very significant burden. They cannot change their election-related practices, including state and local elections, without getting permission from the federal government to do so. It really came out of a long line of litigation regarding the pre-clearance procedure under the Voting Rights Act, which was a very great intrusion into state sovereignty. The court referred to it as an extraordinary exercise of congressional power, and it was into an area that was reserved to the states in the Constitution, which the court referred to as sensitive areas of state and local policymaking. That's just not the case here. The NVRA is an exercise of Congress's election clause power, which is a power that's expressly delegated to the United States under the Constitution, for which the states gave up sovereignty. And the 10th Amendment reasoning in Shelby County doesn't really apply here because the 10th Amendment says that, that powers that are not expressly delegated to the federal government go to the states. But this is an exercise of expressly delegated federal power. And I think as Judge Easterbrook's questions referenced, the elections clause itself doesn't have any sort of equal treatment provision, as some other provisions in the Constitution do require the federal government to treat the states equally. And I think the the burden in Shelby County is much higher. It wasn't just being subject to a federal law that a state has to comply with. It was this procedure of basically going to the US DOJ and begging to be able to change your laws and not being able to do that until you got permission. Now, I would just say that the exemption itself is supported by a rational basis. I mean, there is a reason why Congress did this. It wanted to make registering to vote easier, to get rid of unfair and prejudicial registration practices. It made the choice that states could have same-day registration, polling place registration, where it's a very open and easy procedure to register. So Congress could reasonably conclude that states that had that procedure didn't really need to have all these other things like motor voter or this voting registration list being available at little or no cost. Because to the extent someone was wrongly removed from the polls and didn't know that, they could show up at the polling place, they could still register to vote. I mean, a lot of what the laws that the state laws that the NVRA was targeted at, I mean, there's laws that require you to register 30 days before an election or 60 days before an election, things like that. Maybe you can only register in one location in your county or something like that, trying to make it easier for people to register. Whereas Congress rationally concluded that states with that polling place registration just simply didn't need to be subject to these provisions. That was a choice Congress made. I will note that Wisconsin has somewhat an infringement on its sovereignty to the extent this is an issue of state sovereignty, and that it has to maintain polling place registration in order to maintain its exemption. So if it got rid of polling place exemption, it would have to then be subject to the NVRA. I guess turning to the remedy issue, we think that this is a strange way to vindicate state sovereignty, to have a third party come in and say that Wisconsin should have even more intrusion on its sovereignty in order to perhaps remedy a sovereignty issue with respect to other states in the union. To the extent a party raises an issue like this, we think it should be another state who, maybe feels that they're burdened by this NVRA. They could try to raise a claim like this. I don't know that it would really be successful, but the fact that no state has done this, I think seems to show that perhaps there isn't that kind of level of burden that we saw in Shelby County, where states just don't seem to be too upset about the NVRA applying to them and not to Wisconsin and not to Minnesota and a few other states.
Beyond the remedy question on that, then, prudential standing. Can the foundation satisfy the requirements for third-party standing?
Yeah, we've argued that, the federal government maybe has developed a better argument on that than us. I think we would have concerns that they're raising their own rights in some ways, but in another way, they're raising, other states' rights. We do think there's an issue with them even having a statutory right here, in that usually you have an interest that's recognized by law. So if, like FOIA, as was referenced, gives the requester a right to certain documents, and so the statute gives them the right, whereas here, the foundation is trying to use a statute that expressly doesn't apply to give it the right to any documents to then get documents. So it's a strange situation, and I think there could be prudential standing problems. We think there are Article 3 standing problems as well, and that the statutory right doesn't even apply to them, and then I don't know that their downstream consequences are enough to satisfy that either. Well, if the court doesn't have any other questions, I think I've gone through what I had to say.
Thank you. Mr. Braniff. Good morning.
Good morning, Your Honors, and good morning, Marquette. Andrew Braniff for the United States. May it please the court. The district court correctly dismissed PILF's complaint for failure to state a claim upon which relief could be granted and upholding the constitutionality of Section 4B2 of the NVRA. PILF's challenge to Section 4B, based on Shelby County's equal sovereignty principle, fails for multiple independent reasons. PILF lacks prudential standing to assert it. The equal sovereignty principle simply does not apply to the NVRA, and Section 4B on its own raises no equal sovereignty concerns.
Mr. Braniff, your thoughts on Article 3 standing?
So first off, let me just say, we support agencies or entities like PILF seeking this type of information nationwide. We supported them just last year in their suit against Maine, where they were seeking these types of records from Maine. And we are big believers in the NVRA and HAVA and the Civil Rights Act ourselves, and have been requesting these records around. So we think that public disclosure is an important element of all of these actions, and so we take no position on the Article 3 standing issue. I will say the state does make some compelling arguments with regard to Article 3 standing. The NVRA itself states in Section 10 or 9 that in order to bring a case as an independent entity, you must establish a violation of the statute. Here, there was no violation of the statute. Statute simply doesn't apply to Wisconsin. And so you would think that an entity like PILF might be prevented from bringing a case in those situations. Thank you. The NVRA at its heart requires states to provide simplified systems for registering to vote in federal elections and imposes requirements about just when, how states may remove people from federal voter registrations. In the Acorn decision where the Seventh Circuit upheld the NVRA as a constitutional, satisfying, rational basis, Judge Posner reflected on the Constitution as a jigsaw, all the pieces fitting together. The NVRA is in itself a jigsaw itself. All the pieces fit together, and those pieces simply don't work if you apply them to states that have same-day registration processes. There are systems where states are permitted to register voters up to 30 days before an election. At that point, the list will be set. Well, that makes no sense for a state that has polling place registration because the list will not be set until after the election. Similarly, states cannot remove voters until 90 days before, stop systematic removal of voters starting 90 days before an election to allow voters who are improperly removed the ability to re-register themselves. None of that makes any sense if a voter can just go up and register on the same day. The statute has numerous options for individuals who are registered and then removed from registration to cast provisional ballots on the day, and all those processes for casting provisional ballots. Again, that makes no sense if the person can register anew. And in fact, it would create a two-tier system where individuals who were previously registered but then maybe removed would have to go through a very complicated NVRA process for obtaining a provisional ballot and having that provisional ballot reviewed and approved by the state. But if a person was never registered or claimed they were never registered, they could just walk up and register that day. So the statute works as a jigsaw, and it only works if there is this differentiation between states that have polling place same-day registration on election day and those states that do not. With one note, just with regard to prudential standing that was brought up before, while we have supported PILF before, and we will support PILF in the future, and we will seek these records, in this case, in this time, they are simply the wrong plaintiff bringing the wrong claims. There are possible situations where standing might be conferred upon state entities that might have claims underneath the statute, but they do not have the nexus between the state interest. You can see by the state's position here, they do not believe they have been injured in any way in this case. And so they are not asserting this.
Under that alternative plaintiff scenario, under what circumstances would another state have an interest in invalidating Wisconsin's exception?
Well, they couldn't invalidate Wisconsin's own exceptions, but they could do their own. They could bring this type of claim. In the PILF v. Maine case, for example, Maine could have asserted an equal sovereignty claim under Shelby County in their defense. Shelby County is not cited in their briefing. It was never brought up. And that case was just last year, 11 years after Shelby County was decided. So, I see my time is up.
Thank you very much. Mr. Johnson?
Thank you. I want to start with, I'm not sure this country would exist the way it does if the founders thought the elections clause could be used by Congress to simply pick and choose winners or reward its allies and punish its political enemies. I think this was a compromise between the states and the federal government that was to be used in the last resort. And so if Congress is using it in this way to impose their policy preferences, to pick states that will be burdened and states that won't.
Same-day registration doesn't have a partisan balance to it. It's not that kind of an issue. It's just pro-democracy.
Well, I certainly think that some.
So I don't think this is a, punish your enemies, support your
Well,
allies.
Of course, but it is being, my ultimate point is, if Congress can act in this way, then they could do other things. They could impose voter ID on one state and prevent another state from implementing it. And under the district court's decision, that would require no justification.
Slippery slope, parade of horribles kind of argument.
I want to touch on prudential standing. In both the Bond and the Gillespie case, the government argued that only the states can raise 10th Amendment arguments. And in both cases, the court rejected that argument and said that when the violation of the 10th Amendment causes an otherwise redressable injury, then that plaintiff has standing and is the proper party to challenge a federal statute. One other point on that counsel for Wisconsin made, he seemed to suggest that election day registration or polling place registrations is somehow a substitute for the transparency that Congress intended. It certainly is not. Election day registration may happen at the polls, but it is not immune from discrimination or mistake or error. It is just another mechanism that grants voting rights, and it should be transparent. And I'll leave you with this. Consider this, that Wisconsin has a law that says if an election day registrant fails address verification after an election, they are made ineligible and sometimes referred to the district attorney for prosecution. And I think when you have criminal penalties on the table, the process needs to be transparent. Thank you.
Thank you very much. Our thanks to all counsel. The case is taken under advisement.